What's good, everybody? Welcome back to the channel. This is Carl from Sovereign Citizen Chronicles. Today, we're back in the courtroom with Judge David D. Wolfe out of the state of Tennessee. This is going to be a continuation of the Sherrick Vaughn trial, part 3. All right, parts 1 and 2 will be down in the description below the video. Also, I just want to let you know this was about 5.5 hours of footage. I was able to get it down to about 4 hours. There was a lot of stuff in there that wasn't necessary to have in the video, like when they let the when they dismissed the jury from the courtroom and when they brought them back in. I got rid of those parts, and there was times when there was recesses and stuff like that. So when you see those edits or those chops, that's why they're in there. Those are parts that wasn't really necessary for you to watch. All right. So I did put in a little bit of work on this, but I think it was all worth it. So, with that being said, let's get to the conclusion of this trial.
Through this initial charge. The defendant, Sherrick Vaughn, is charged in the indictment in count 1 with the crime of assault. In count 2, the defendant is charged with false imprisonment. In count 3, the defendant is charged with disorderly conduct. In count 4, the defendant is charged with public intoxication. The defendant pleads not guilty to each and every offense embraced in the indictment. Before we begin the trial, I would like to tell you a little bit about what will happen during the course of the proceedings. I want to describe basically how the trial can be conducted and what the attorneys, jurors, and the judge will be doing over the course of the trial. At the end of the trial, I will give you more detailed instructions on how you're to go about reaching your decision, but now I simply want to explain to you how the trial will proceed. The law applicable to this case is stated in these instructions and those that follow, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out one or more of them to exclusion of another or others, but should consider each one in the light of and in harmony with the others. Ladies and gentlemen, if you will step across the way, let me conclude that you can just put those in your seat, those instructions in your seat, and go ahead and step across the hallway so I can deal with one matter that's come up to my attention, okay? Just leave those in the courtroom, and if you will, please. All right, I've been handed a note that Mr. Vaughn indicates he needs to use the bathroom. So before I go any further, since it will take me 15 minutes to read the rest of these, we'll let Mr. Vaughn step outside into the holding area and use the restroom. And then as soon as he's concluded with that, bring him back in and we'll resume. You can sit anywhere you want now. Spread out, change seats, find you a partner to sit by if you want to, whatever you want to do. We only need the assigned seating when we were going through the jury selection process. I apologize. I've told you before, some days are really smooth and some days are just like on a bumpy road in rural Dixon County, but we're going to start back with the first full paragraph on page 2. You'll follow with me, and it begins, the law applicable to this case is stated in these instructions and those that follow, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out one or more of them to exclusion of another or others, but should consider each one in the light of and in harmony with the others. The defendant has been charged by the state of Tennessee with a violation of state law. The document containing the charges is referred to as an indictment. An indictment is the formal accusation charging a defendant with a crime and is not evidence of anything. The defendant is charged in count 1 with assault. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt that the defendant intentionally or knowingly caused another to be in reasonable fear of imminent bodily injury. The defendant is charged in count 2 with false imprisonment. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt that the defendant knowingly removed or confined another unlawfully, so as to interfere substantially with the other's liberty. The defendant is charged in count 3 with disorderly conduct. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt that the defendant intentionally, knowingly, or recklessly created a hazardous or physically offensive condition by an act that served no legitimate purpose or make an unreasonable noise which prevented others from carrying on lawful activities in a public place with the intent to cause public alarm or annoyance. The defendant is charged in count 4 with public intoxication. For to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt that the defendant was under the influence of an intoxicating substance to the degree that the defendant may have been endangered, that there was endangerment to other persons or property, and unreasonably annoyed people in the vicinity in a public place, either intentionally, knowingly, or recklessly. The defendant has pled not guilty to the charges. He is presumed to be innocent and may not be found guilty by you unless, after hearing all of the evidence, attorneys' arguments, and instructions of law, the 12 jurors seated in this case unanimously found that the state has proven its case beyond a reasonable doubt. First step in the trial will be the attorney's opening statements. The state will tell you about the evidence it intends to present so that you will have an idea of what the state's case is about. This opening statement is not evidence. Its only purpose is to help you understand what the evidence will be and what the state will attempt to prove. After the state's opening statement, an attorney or the defendant may make an opening statement if he or she should so choose. Again, statements of attorneys are not evidence. Next will be the state's case in chief, in which the state will present its evidence. The evidence in the case will most likely consist of physical exhibits, documents, and the testimony of witnesses. The witnesses will testify by answering questions asked by the attorneys. Venue of the offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by a preponderance of the evidence that this offense was commenced or consummated in Dickson County, Tennessee, then you must return a verdict of not guilty. After the state completes its case in chief, the defense will be given an opportunity to present evidence through witnesses and exhibits. A defendant is not required to put on any evidence or to testify. The burden is always on the state to convince you that the defendant is guilty beyond a reasonable doubt. If the defense does present proof, the state may then put on what is known as rebuttal proof. After the state's rebuttal, the defense may put on further proof. After you've heard all of the evidence, the state and the defense may present final arguments. I previously told you that opening statements by the attorneys are not evidence. Likewise, closing arguments are not evidence. In closing arguments, the parties will attempt to summarize their cases and help you to understand the evidence that was presented. The final part of the trial occurs when I instruct you about the rules of law that you're to use in reaching your verdict. After you hear my instructions, I will select and excuse the alternate jurors, and the final 12 jurors will leave the courtroom together as a group. You will then begin your deliberations to make a decision in the case. Your deliberations will be secret, and you will not be required to explain your verdict to anyone. Now that I have described in outline form the trial itself, let me explain the functions that you and I will perform during the trial. I will decide which rules of law apply to the case. My decisions will be reflected in my responses to the questions and objections that the attorneys raised during the trial, as well as in my final jury instructions. It is your job to determine what the facts are from the evidence. You must then apply the law and my instructions to the facts, and from that application, you will arrive at a verdict. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden remains on the state throughout the entire case. Keep in mind that the defendant is presumed to be innocent of the charges against him. Thus, the defendant is not required to prove his innocence, to have his attorney make any statements or arguments, or to produce any evidence. Reasonable doubt is that doubt created by an investigation of all of the proof in the case and an inability, after such investigation, to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the offense. You, as jurors, must decide whether the state has proven beyond a reasonable doubt that the defendant committed the crimes charged in the indictment. You must consider the evidence in each count separately. You must base that decision only on the evidence in the case and my instructions about the law. Witnesses will testify in response to questions from the attorneys. Witnesses are first asked questions by the party who calls the witness to testify, then the other side is permitted to cross-examine the witnesses. Although evidence is presented by asking questions, the questions themselves are not evidence. An insinuation contained in a question is not evidence. You should consider a question only as it gives meaning to a witness's answer. In addition, members of the jury may ask questions of the witness if desired. The procedure for a juror to ask a question of the witness is that the question must be written down and submitted to me. Do not put your name on the question, as the questions of the jury are required to be anonymous. If a juror has a question that he or she would like to have asked of a witness, that question must be submitted in writing while the witness remains on the witness stand. At the end of the witness's testimony, the jury will be excused and I will consider the questions of the jury on the record. Then the jury will return to the courtroom. If the question is allowed by the rules of evidence, the question will be asked either by me or by one of the lawyers. You should not place any significance upon the fact that I asked the question of the witness or whether one of the lawyers asked the question. In either event, the question is being asked by the witness solely because it was desired by a juror. The wording of the question may be altered by me, or the question may not be asked at all. If the question is altered by me, you must assume that I had a valid legal reason for altering it, and you should place no significance upon this fact, nor should you draw any inference from it. I may refuse to ask the question at all. In that case, you likewise should place no significance upon this fact, nor should you draw any inference from it. Many times our rules of evidence do not allow certain questions to be asked, even if both sides desire to do so. After the trial, if you wish to know the answer to your question or the reason it could not be asked, please ask after court is adjourned and I will attempt to explain it to you. An important part of your job will be making judgments about the testimony of witnesses who testify. You should decide whether you believe what each person says and the importance of his or her testimony. In making that decision, I suggest that you ask yourself a few questions. Did the person impress you as honest? Did he or she have any particular reason not to tell the truth? Did he or she have a personal interest in the outcome of the case? Did the witness have any motive, bias, or prejudice that would influence the witness's testimony? Did the witness seem to have a memory of the events he or she testified about? Did the witness have the opportunity and ability to observe accurately the things he or she testified about? Did he or she appear to understand the questions clearly and answer them directly? Was the witness distracted in any way? How did the witness look and act while testifying? Was the witness making an honest effort to tell the truth, or did the witness evade questions? Did a witness's testimony differ from the testimony of other witnesses? Another factor for you to consider in evaluating a witness's testimony is whether the witness's testimony during cross-examination appeared to be contradictory, unreasonable, and improbable. However, immaterial or minor discrepancies or differences should not affect the believability of a witness unless it should plainly appear that the witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony or by the facts and circumstances proved on the trial. As the sole judges of the facts, you must determine which of the witness's testimony you accept, what weight you attach to it, and what inferences you will draw from it. The law does not, however, require you to accept all of the evidence. In deciding what evidence you will accept, you must make your own evaluation of the testimony given by each of the witnesses and determine the weight you will give to that testimony. You must decide which witnesses you believe and how important you think their testimony is. You are not required to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. There is no fixed set of rules to use in deciding whether you believe a witness. In making up your mind and reaching a verdict, do not base any decisions on the fact that there are more witnesses on one side than on the other. Likewise, do not reach a conclusion on a particular point just because more witnesses testified for one side on that point. Your job is to think about the testimony of each witness you heard and decide the facts. At times during the trial, an attorney may make an objection to a question that is asked by another attorney or to an answer that the witness gives. This simply means that the attorney is requesting that I decide on a particular rule of law. Do not draw any conclusions from the fact that an objection was made or from my rulings on that objection. My rulings only relate to the legal questions that I must determine and should not influence your thinking. If I sustain an objection to a question, the witness will not be permitted to answer the question. Do not attempt to guess what the answer might have been had the witness been permitted to give it. Similarly, if I tell you not to consider a particular statement that was made, you should put that statement out of your mind and you may not refer to that statement in your later deliberations. In deciding this case, you may not draw any inference from an unanswered question, and you may not consider testimony that you're instructed to disregard. Any arguments about objections or motions are usually required to be made by the attorneys out of the hearing of the jury. Information may be excluded because it is not legally admissible. Excluded information cannot be considered in reaching your decision. A ruling that is made on an objection or a motion will be based solely upon the law. You must not infer from a ruling that I hold any view or opinion for or against any party in this lawsuit. Some of you have probably heard the term circumstantial evidence and direct evidence. These are the two basic types of evidence that exist in law. Direct evidence is direct proof of a fact, such as the testimony of an eyewitness. Direct evidence is those parts of the testimony admitted in court which refer to what happened and was testified to by witnesses who saw, heard, or otherwise sensed what happened firsthand. If witnesses testified about what they themselves saw, heard, or otherwise sensed, they presented direct evidence. Circumstantial evidence is all of the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all of the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. The court will not provide you with a transcript of the testimony at the end of the trial. Therefore, you must listen very carefully to the testimony. Each of you will be allowed to take notes during the trial for your own use during your deliberations. You are not required to take notes. Independent memory can be as accurate as written notes. You'll be provided with paper and pen if you decide to take notes. There are several rules concerning your conduct during the trial and during recesses that you should keep in mind. First, do not discuss the case among yourselves during the trial until I instruct you on the law and you start deliberating at the end of the case. You must keep an open mind until you have heard all of the evidence, the attorney's closing arguments, and my final instructions concerning the law. Any discussions before the conclusion of the case would be premature and improper. Second, during the course of the trial, you should not talk with any witness, defendant, or attorney involved in this case. Please do not talk with them about any subject whatsoever. You may see them in a hallway or on an elevator or at some other location. If you do, perhaps the best standing rule is not to say anything. Third, do not permit any other person to discuss the case in your presence. If anyone does attempt to do so, report this fact to the court immediately without discussing the incident with any of the other jurors. I do not know if there will be any media reports in the newspapers, on TV, or on the radio about this particular case. If there are, you are not permitted to read, watch, or listen to those reports. You as jurors must base your decision solely on the evidence you hear in the courtroom. You may not communicate with anyone or provide any information, photographs, or video to anyone by any means about the case on your cell phone, through email, Android, iPhone, text messaging, video, FaceTime, Google Duo, Zoom, Facebook Messenger, Skype, or through any blog or website, through any internet chat room, or by any other social networking website, including but not limited to MySpace, Facebook, Instagram, Snapchat, Twitter, LinkedIn, TikTok, Meetup, Pinterest, Reddit, and YouTube, especially including the live stream of this trial. In keeping with the state of Tennessee's open access to the court's public policy, the majority of court proceedings are live streamed via YouTube. You as a juror are not recorded on video and shown on camera. You are not permitted to read, watch, or listen to those YouTube streams during the trial. You as jurors must base your decision solely on the evidence you hear in the courtroom. I will remind you of your duty and responsibility before all breaks in jury out hearings, and trust you will follow my instructions in keeping with the integrity of the case in the court proceedings. During the course of the trial, you will receive all of the evidence you may properly consider to decide the case. Because of this, you should not attempt to do any research on your own or gather any information on your own that you think might be helpful. Do not conduct your own private investigation into this case, although you may be tempted to do so. For example, do not visit the scene of an incident, read any textbooks or articles concerning any issue in this case, or consult any other source of information. If you were to do that, you would be getting information that is not evidence. You must decide this case only on the evidence and law presented to you during the trial. Any juror who receives any information about this case other than that presented at trial must notify the court immediately. Finally, during the course of the trial, I may have to interrupt the proceedings to confer with the attorneys about the rules of law that should apply. In some cases, we may have bench conferences in the courtroom outside of your hearing. And in some instances, I may ask you to retire to the jury room while we discuss a matter out of your presence. I will try to avoid as many of these interruptions as possible. I ask your patience because these interruptions are necessary points in the trial where we have to resolve legal issues. In the long run, they save time for all of us. If anyone needs a break at any time, please do not hesitate to ask. Simply raise your hand. If I do not see you, get the attention of one of your court officers who will advise me that a juror needs a break. Normally, I will try to conclude the testimony of a witness before taking a break. The usual break times are at 10:30 in the morning and 2:30 in the afternoon, with a normal hour between 12 and 1 for lunch. If you need a break at any other time, please ask. A juror who is distracted is not paying full attention to the testimony. Both parties are entitled to your full, undivided attention to the case. If after your deliberations you find the defendant guilty of any offense, the court will set the punishment at a separate sentencing hearing. The jury will not be involved in setting the punishment. This completes my opening comments to you. The next phase of the trial is the formal reading to you of the indictments in this case. General Bryson.
In the Circuit Court for Dickson County, Tennessee, at Charlotte, November term grand jury 2022. The grand jurors of Dickson County, Tennessee, duly impaneled, sworn upon their oaths, do present that on or about August 30th, 2022, in Dickson County, Tennessee, and prior to the finding of this indictment, Sherrick Vaughn then and there did intentionally and knowingly cause Bethany Page to reasonably fear imminent bodily injury in violation of Tennessee Code Annotated 39-13-101 and against the peace and dignity of the state of Tennessee. Count 2. And the grand jurors aforesaid, upon their oaths aforesaid, do present and say that on or about August the 30th, 2022, and prior to the finding of this indictment in the county and state aforesaid, Sherrick Vaughn then and there did knowingly and unlawfully remove or confine Bethany Page so as to interfere substantially with Bethany Page's liberty in violation of Tennessee Code Annotated 39-13-302, all of which is against the peace and dignity of the state of Tennessee. Count 3. And the grand jurors aforesaid, upon their oaths aforesaid, do further present and say that on or about August the 30th, 2022, and prior to the finding of this indictment, in the county and state aforesaid, Sherrick Vaughn then and there, in a public place, with intent to cause public annoyance or alarm, did unlawfully cause a disturbance by Sherrick Vaughn, being loud and disruptive, and engaged in fighting or in violent or threatening behavior, or creates a hazardous or physically offensive condition by any act that serves no legitimate purpose, or made unreasonable noise which prevented others from carrying on lawful activities in violation of Tennessee Code Annotated 39-17-305, all of which is against the peace and dignity of the state of Tennessee. Count 4, and the grand jurors aforesaid, upon their oaths aforesaid, do further present and say that on or about August 30th, 2022, and prior to the finding of this indictment, in the county and state aforesaid, Sherrick Vaughn then and there did unlawfully appear in a public place under the influence of a controlled substance or any other intoxicating substance to the degree that the offender may be endangered, there is endangerment to other persons or property, or the offender unreasonably annoys people in the vicinity in violation of Tennessee Code Annotated 39-17-310, all of which is against the peace and dignity of the state of Tennessee. Signed, W. Ray Crouch, Jr., District Attorney General.
To that indictment, how do you plead, Mr. Vaughn? Plea of not guilty is entered. All right, ladies and gentlemen, the next step would be for the state and the defense, if they choose, to make an opening statement. Do you wish to make an opening statement, General? All right.
At the time that this case happened, Bethany Page was the clerk at the Exxon there across from Walmart, but in front of the post office. And the defendant had been a customer at times before, come in and out of the store. She had seen him. But on this particular day, he came in, and she will tell you that she smelled alcohol on him and that from the very beginning of him entering the store, he was yelling, he was loud, he was accusing her, using a different name not hers, of being an informant for the drug task force. They argued back and forth some, other customers came in the store, Mr. Vaughn left, and he held the doors, preventing her from coming out. That will be the proof that you will hear substantially for all of these counts. You'll also hear from the officers that came about Mr. Vaughn's behavior when they arrived, and anyone else that was there. You will hear that the defendant's girlfriend was present, but officers and Ms. Page will tell you that she did not go into the store. She was in the car during this interaction. And so your primary proof will be the testimony that you hear from Bethany Page about what happened to her on this day. Now, at the end of this, we'll come back to you and ask you to return a verdict. Thank you.
Mr. Vaughn, do you wish to make an opening statement?
Good evening, y'all. I'm sorry, I'm not 100%. I got a headache. Y'all look, I see stars all the way around y'all. Please forgive me that I'm not more invested in this, I guess, when it's been all about me. What the state has said, basically I can say that you're gonna hear a lot of hearsay evidence, no one with firsthand knowledge. You're gonna hear basically a lot of he said, she said with nothing to back it. And I'm here to prepare and show you that today. Thank you.
All right, state may call your first witness.
State calls Bethany Page.
Bethany Page. Page, if you'll come right up here. Ask you to face our clerk and raise your right hand and be placed under oath.
Are you Bethany Page?
Yes, ma'am, I am.
All right, I'm gonna ask you, you gotta pull that microphone up and speak into it. You're a pretty loud talker, but these people have to hear everything that you say, okay?
Yes, ma'am.
Okay. Would you spell your first name and your last name for our court reporter?
First name is Bethany, Bethany. Last name is Page, Page.
And in August of 2022, where were you working?
Exxon,
Now, there are a couple Exxons in Dixon.
the one that is connected to Crystals.
Okay. And that is in Dixon County.
Yes, ma'am.
And we're talking about the one, I think law enforcement calls it Malfunction Junction.
Pretty much, yes.
Okay. So Walmart is kind of across from you, the post office behind you.
Yes, ma'am.
Do you still work there today, some?
I sure do.
But it's not the Exxon anymore. What is it now?
It's called Shell Station now.
Shell. All right. On August the 30th of 2022, did the defendant come into the store?
Yes, ma'am.
Okay. And you recognize him sitting here today.
Yes, ma'am.
Judge, if the record would reflect that she has identified the defendant.
All right, the record will so reflect.
And had he ever been in the store before?
A couple of times to buy dip and all that, nothing major.
Had you had any disagreements with him previously?
No, ma'am.
When he came in the store on August the 30th of 2022, what was his demeanor?
Like, he just pulled up and he started being irate. Or like,
Let me back up. Where did he pull up?
in front of the store, in front of the door.
So not at a gas pump.
No, ma'am.
Was he in a parking space?
No, ma'am.
So he parked directly in front of the doors.
Yes, ma'am.
Okay. Did that catch your attention?
Yes, ma'am, it did, because, like, I was wondering why would someone pull in front of my door like that?
Did was he driving or was he the passenger?
He was driving.
Were you able to see if anyone else was in the vehicle?
Yes, ma'am.
Did anyone get out of the vehicle with him?
No, ma'am. It was just him.
Was there a long passage of time before he came in, or did he come right in?
He came right in as soon as he pulled in front of the gas station.
Okay. So let's talk about him walking through the doors. Does he come straight up to you, walk around, or something else?
He came up to the counter and started ranting, raving, cussing, and everything else to me.
What types of things was he saying?
That I'm gonna beat your ass. You're the informant for the TBI. You set my girlfriend up. The whole 9 yards.
And have you ever been an informant for law enforcement?
No, ma'am.
How did you respond to his behavior?
Well, to be honest, I got a little bit angry and scared at the same time.
Okay. Tell me, does he stay on the opposite side of the counter from you? Tell me what goes on after this.
Yes, he stayed on the opposite side because I was behind the counter checking customers in. Before he came in, then after the customers left, that's when he came in, started cussing me, calling me names. I'm gonna beat your ass. That I was his girlfriend. Jessica tried to set her up or something like that.
He thought you were Jessica.
Yes, ma'am.
Now, let me get this timeline a little bit clear, because you said he came right up to the counter, but then you said something about he came up after customers were being checked out. Can you clarify for me?
Because there was one customer in the store before he came in. And after he left, he came up to the counter, and that's when he started ranting, raving, and cussing.
Okay, so you got two he's. So the other customer leaves, and then the defendant comes in.
Yes, ma'am.
Okay. So was anyone in the store when he first came up to you?
No, not at the time, no.
How long do you think he was in the store with you?
Maybe 15, 20 minutes at the max, as far as I can remember.
And were there any other customers that came in during that time?
Yes, ma'am.
Tell me about that.
It was one, then when the customer came in, the situation kind of settled down because he was talking to the other customer, then they both left.
The defendant and the other customer
Yes,
both
ma'am.
left. Okay. When he told you, and are you quoting him when you say, "I'm going to beat your ass"?
Yes, ma'am, I am.
Okay. Were there any other specific threats he made to you?
No, ma'am.
Did he say that one time or more than one time?
More than once. Like a couple of times or so.
And when he said that, paired with his behavior, what were you thinking?
What am I going to do? That's when I called 911.
Did you think he might actually attack you?
Yes, ma'am, I did.
Okay. So you called 911, and what did you tell them?
I told them there's an outrageous customer that was threatening to beat me up, cussing me, and all that. They needed to come as soon as possible.
So the defendant had already left the store by the time the police arrived.
Yes, ma'am.
Okay. When he left, did you stay in the store or did you attempt to go
I
outside?
attempted to go out, but I went back in because I had a customer come in afterwards.
Why were you attempting to go out?
See which direction he went to, just in case the cops did come, and tell him which way that he went.
Were you able to go outside or did something prevent you?
Something prevent me was a customer that came in at the time.
Okay.
After everything settled down and he left.
Did Mr. Vaughn do anything preventing you from leaving?
A couple of times he was standing in front of the door, would you let me out? Because I was telling him to leave, you need to leave my store and the whole 9 yards.
Would you have been able to leave with where he was standing?
No, ma'am.
Did you have any reason to believe he was under the influence of anything?
Yes, ma'am, because when he came up to the counter and he smelled like straight up alcohol, because I knew he's been drinking because his eyes was bloodshot red and I did smell the scent of alcohol on him.
Was he slurring at all?
I don't remember.
Was he steady on his feet?
Like I said, I can't recall on that one either.
But you do remember the odor of alcohol in his bloodshot eyes?
Yes, ma'am.
When he had come in previously, had you noticed him being under the influence?
No, ma'am. He was always calm, cool, joking around with me, the other customers.
Now, the store there at Exxon, and this is going to sound like a silly question, okay, is that open to the public?
Yes, ma'am.
The words that he was using when he talked to you, was he using other cuss words, other language?
He was saying F-U, B-I-T-C-H, and that's pretty much it.
Was he talking about the volume we're talking now, or was he louder?
He was a little bit louder. He was outright, just put it that way.
Now, were you able at any point to see the other person in the vehicle?
I seen a glance of her, but I don't remember what she looks like at all.
When you saw her, did you recognize her as someone that you knew?
No, ma'am, I do not. Because I never seen her before.
Did he was screaming at you. Was he also screaming at any of the other customers or just you?
Just me.
When he was screaming, was he standing completely still, moving
He
around?
was moving around,
What was he doing with his hands and arms?
raising them up, act like he was going to hit me, or I'm not for sure if he had something in his hand or not.
Now, this was August, so it's summer.
Yes, ma'am.
Okay. What time of day did this happen?
I will say between 5 and 7 because it was still daylight outside.
And what was he wearing a shirt?
As far as I can remember, yes.
Okay. So if he had had a weapon, would you have been able to know?
No, ma'am.
One moment. Have you ever gone by the name Jessica?
No, ma'am, I have not. My name's always been Bethany.
Nothing further, Judge.
Mr. Vaughn, you have the right to cross-examine this witness if you wish to ask questions.
Yes, sir, I do. 1 second.
All right, if you'll come to the podium, please.
How are you doing today?
Good, how are you?
All right. You stated that you're familiar with me.
Yes, I am.
Would you state for the record how you were familiar with me?
You were a customer at my gas station. You came in there a couple of times before.
And you stated that what did I normally come in there and do?
You buy a dip or cigarettes or something to drink.
Okay. How long ago did this incident happen between you and I?
3 years ago.
Okay. So your memory of this is all fresh today?
No.
It's not fresh today?
It is because I read the police report and I do remember some of it.
Okay, so the police report helped you refresh your memory.
Because I actually forgot all about it until they reached out to me.
How long ago did they reach out to you?
About a month and a half ago.
Okay, and it brought your memory back? Okay. And how do you feel about that incident?
I just wanted it to go away
You just wanted to go back and you didn't?
because I'm missing work right now.
No, I can understand that. I imagine you are. Um, is the crystals, is the Exxon connected to anything?
It's connected to crystals.
Is there any way to the crystals?
Yes, there's a door inside of Exxon that you can go through crystals to.
Okay. It's not blocked or anything?
No.
Okay. You stated that when this incident happened with you and I, that there wasn't any other customers in there.
Not at the time, no.
When I entered the store, there was none in there?
No.
Okay. And you stated also that I came straight to the counter and started cussing you.
Yes, sir, you did.
And then you stated that also that I stayed in the store for about 15 minutes, just walking around afterwards, correct?
As far as I can remember, yes.
You didn't feel the need to grab a cell phone or a telephone and call for help?
Well, at the time, no, but when you started being outright cussing, that's when I did grab my phone and call 911.
And you stated I cussed you when I walked in the store, correct?
Yes, sir.
And then I was walking around the store for 15 minutes,
Yes, sir.
and you called the police while I was still in the store.
I sure did.
Okay. Did the police arrive while you were was I in the store?
No.
But I
You
was-
already left the property.
I was in the store for about 15 minutes. How long would you say that you talked to the police before I left the store?
About, as far as I can remember, about 5 or 10 minutes after you was in the store, that's when I called.
About 5 or 10 minutes. Okay. Have you ever been arrested before?
We're going to need a jury out.
Ladies and gentlemen, if you'll step across the way. I would remind you not to discuss this case with each other until you come back in and the case is concluded.
Your Honor, I have a mind at this moment to ask for a mistrial. The defendant was advised before court that there was no history to be asked about. He can't ask about arrest. He can ask about convictions, but she doesn't have any that are admissible. This is an attempt to sway the jury with inadmissible information.
Your Honor, I had no intent on doing that. You stated that I could ask certain questions surrounding that. Her convictions, I mean, I can reword it for you.
You don't need to. You've already asked the question that was impermissible. The question that you could ask was, have you been convicted of a felony or a crime involving moral turpitude or dishonesty? That was instructed to you this morning. You even asked me to define what was a crime of dishonesty. You were, having been instructed what the 2 questions you could ask were, you asked one that was not permitted. So the options I have are to bring the jury back and instruct the jurors that you were specifically advised and instructed by the court not to ask that question, that it was impermissible. Or I can grant the state's motion for a mistrial if that's what they choose to do, and we'll have to grant a mistrial. And it would not be creating for you double jeopardy, because a mistrial that results from the defendant's own misconduct is not a bar to a future prosecution. It would just mean that this case gets rolled to January and we come back to it then.
Why January?
Because I'm not here again until January.
Can another judge sit in? We're under a speedy trial still.
They can, but I've heard all the motions that you have filed, and therefore I would be the one.
I don't think anybody can do any different.
Pardon?
I don't think anybody can do any different.
I tend to agree with you. General Bryson, do you wish to have a mistrial, or do you want me to instruct the jury?
Judge, I will not ask for a mistrial at this point. If there are any other inadmissible questions, I will return to this issue. I would ask that the jury be instructed.
I will. Bring the jury back. Mr. Vaughn, please make sure that you do not ask any inadmissible questions. If you have a question that you want to ask that you think might be inadmissible, then you need to ask it outside of the jury's presence. We'll have a jury out hearing.
Well, while they out, I got a question for you. Then you should have said something.
Stop him for a moment. What do you have?
My next question I was going to ask, was she on drugs?
That would not be admissible.
Okay.
I mean, Judge, if he's attacking, hold on. If he's attacking her ability to perceive, remember, I mean, I think he can ask, was she under the influence of drugs at that time?
You're talking about at the time of this occasion?
Of course.
Yes. I don't think he can ask, during the time frame, have you ever used drugs? Did you use drugs? I think it is permissible to ask at the time that this happened in the store.
Right.
Answer present, correct?
You can ask the question, was she under the influence of any drugs or controlled substances at the time that this incident occurred 3 years ago?
Okay.
All right. Bring the jury in. All right. Thank you, ladies and gentlemen, for your patience. I'm going to instruct you about something. There are rules of evidence or rules of procedure that I've told you about that I have to enforce. Prior to the beginning of this case, there were certain issues that were raised, and Mr. Vaughn is representing himself, but nonetheless, he was instructed that there were certain questions that were not permissible. He just asked a question that was not permissible, and I have sustained the state's objection. I told you before in my instructions that the questions themselves are not evidence. So the fact that he asked a question that was impermissible should not raise any inference, nor should it create in your mind any question about this witness's character in any way, shape, form, or fashion. The question that was asked was impermissible. It had been ruled on earlier, and therefore I'm instructing you to disregard the question and not to attach any significance or not to try to infer what the answer might have been had he been permitted to ask that question. And I've instructed Mr. Vaughn to avoid asking any such questions in the future. Mr. Vaughn, do you have any other questions?
Yes, I do. Have you ever been arrested for any felonies?
No,
At the time of this incident, were you on drugs?
I was not, no.
You were not on drugs. You stated that I was a customer at this store previously. You've seen me multiple times before, correct?
Yes, sir.
Did I always park in the same spot when I came to this store?
No,
Okay. Did I buy anything from you when I entered that store?
no. As far as I can remember, no.
After I allegedly said these things to you, I just chose to wander around the store?
Yeah, you was close to the front door walking around, then you left when I called the cops. And that's when the other customer came in and y'all both left.
Okay. You said that I was speaking to another customer in the store?
Mm-hmm.
Okay, and was we loud or laughing?
No, you was talking normal to him.
I was talking normal to him. Did you feel any fear at the time? Or
I
threatened?
did, that's why I called 911 for.
So you felt fearful. Did you ask me to leave the store at that time?
I sure did, and you kept on saying no. I asked you numerous times to leave my store, and you never did.
And this is why I was talking to the other customer too?
Hmm?
Did the other customer say anything?
As far as I can remember, no.
They didn't intervene or, did you just say that I also was acting normal at this time, speaking to that customer?
You was, yeah. Because
Okay,
you wasn't outright, you wasn't cussing, you wasn't yelling or anything like that.
so me telling you, no, I'm not leaving your store is an irate and,
No, because your demeanor was different when you was talking to me and the customer. Your demeanor was different.
what would you say? I'm like a normal person?
The way you was talking to the customers, like me and you talking now.
Okay. Would you say that I was under the influence of something?
Yes,
What do you believe I was under the influence of?
alcohol.
Okay. You stated earlier to the state that you tried to leave the store but was prevented by a customer because you had to go check them out.
Yes.
Is that like normal fear tactics or something to go check out a customer?
Yes, because the way your demeanor was, I was making sure you left my property and see which direction you went to so I can tell the officer when they showed up.
What direction did I go?
You went the right towards Events Auto Park.
I believe earlier you stated to the state that you didn't know which direction I went because you went back in the store to check out a customer.
Exactly, but when the customer left, I walked outside and seen what direction you went to.
Okay. Was you still in fear?
When you left, no.
Okay. I was in the store, did you say anything else to me besides get out the store?
As far as I can remember, no.
Okay. You were behind the counter when I came in the store, correct?
Yes.
When did you come from behind the counter?
When I really don't recall that one when I did.
Was I still in the store when you came from behind the counter?
Yes.
What was your purpose from coming from behind the counter?
Trying to get you to leave my store.
So you were gonna physically make me leave?
No.
Please.
I was trying to get you to walk towards the door so you can leave.
And how were you gonna do that? Please explain.
There's no way to explain it. I was walking towards you. I wasn't going to hit you or anything. I just wanted you to leave my store.
And you were scared doing that?
Yeah, I was.
Okay. You stated earlier also that I prevented you from leaving the store. Can you please explain in your own words?
You was standing in front of my, the store door, so I couldn't walk out.
Is this
Where-
also where the vehicle was parked?
Yes, in front of my doors,
Was I inside the store or outside the store?
out the store.
Inside the store. Okay. And Crystal's door was still open?
No, it was not, because it was locked.
It was locked. Is it always locked?
No, but when I'm there, most of the time, it is locked.
Why is it locked at 5 p.m.? You told the state earlier it was about 5 p.m. this incident happened.
Yes, like I just said, most of the time when I'm working, I keep that door locked.
Oh, you keep it locked.
Yes,
So you can unlock this door when you want to?
I sure can.
Oh, okay. Okay, so if you needed to leave the store that way, you could if you needed to, correct? Okay. So did you feel like you was trapped?
Not at the time, no.
Okay, thank you. No more questions.
Redirect.
One moment, Judge. No redirect, Your Honor.
All right, thank you, ma'am. You may step down, and is she released from her subpoena?
Judge, I would ask that she remain under the rule.
All right. If you will step outside and remain under the rule in case you need to be called again. State may call your next witness.
State would call Corporal Jeffrey Clark, who goes by Scott.
Clark, step around, raise your right hand, be placed under oath.
Are you Corporal Jeffrey Clark?
Yes, ma'am.
And you also go by Scott,
Yes, ma'am.
which is what I was trying to remember when I called your name.
It's okay.
Would you spell your first name and your last name for our court reporter?
My first name is Jeffery, and my last name is Clark.
Corporal Clark, were you working on August the 30th of 2022?
Yes, ma'am.
And how were you employed at that time?
I was a patrol officer for the City of Dixon Police Department.
And how long have you been in law enforcement?
Going on 5 years.
So you would have been about 2 years in at that point?
I believe so, yes.
And has all of that time been with the City of Dixon?
Yes, ma'am.
Corporal Clark, did you receive a call out to the Exxon on that day, April the 30th?
Yes, ma'am.
Not April, August the 30th? Were you the first officer on scene?
No, I was not.
What officers arrived before you?
2 agents with the 23rd Judicial Drug Task Force.
Is it normal for the drug task force to respond to calls in the city?
If they're close to one that has come out, especially a priority one, which is calls that require lights and sirens, if they're close to it, they will respond until the other city cars get there.
And did dispatch categorize this as a category or a priority one?
To my knowledge, yes.
Do you know about how long they got there before you?
I do not an exact time frame.
Would it have been minutes?
A couple minutes, yes.
When you arrived, tell us where all of these different parties are.
When I arrived on scene, the 2 agents with the drug task force were already out with Mr. Vaughn and his girlfriend at Advanced Auto Parts.
And Advanced Auto Parts is, where is that located connected to or relative to the Exxon?
Right next door.
Do they share a parking lot?
Actually, let me rephrase that. I believe Dixon County Tire and Oil, I think, is in between them.
Okay, so it's some distance over.
One business over.
Would the defendant have had to get back on the main road to go over, or can he traverse through parking lots?
I believe you'd have to go out and into another parking lot.
Who did you speak to first?
I spoke to the agents on scene.
And then who did you speak to next?
Mr. Vaughn.
And what statements did Mr. Vaughn make to you about what happened?
He advised that he got into a disagreement with the female inside the store.
Did he elaborate on that disagreement?
Said that there was some argument going on between the female in the store and his girlfriend.
And did he make any statements about his actions in the store?
Other than that, no.
Did he tell you anything about leaving the store and holding the doors?
I believe he said something about holding the door.
What was his explanation for that?
Off the top of my head, I do not know.
But he did make an admission to you to hold the door.
Yes, ma'am.
Would you have put in your report why he told you he held the door?
I don't believe he gave me an exact reason.
Okay. Who did you speak to next?
I believe I went over and, well, actually, I spoke to Miss Dozier at that time, but she was very hesitant to tell me anything of what happened.
Let me ask you this. When you went up to speak to the defendant, what was his overall demeanor?
Pretty upset.
Were you able to get his name from him?
At first, no.
Did you ask him who he was?
We did.
And once or more than once?
How many times, I do not recall.
Did you ask his girlfriend who he was?
We did.
Would she give you his name?
No.
Were you ultimately able to identify him as Sherrick Vaughn?
Yes, ma'am.
Okay. And that's the same person that's seated here at council table?
Yes, ma'am.
Get a statement from him. Ms. Dozier, would she talk to you at all or just didn't want to say anything?
Didn't really want to say anything.
Next, who did you talk to?
After that, I went and spoke to Bethany.
Were you able to view any of the surveillance footage from the store?
The full-on video, no, but she showed me a still shot after she described her sequence of events. And a still shot showed Mr. Vaughn with his hands up in the air. And in my report, I remember notating that there was a customer in there when he had his hands in the air.
Now, let's talk about body cameras for a second. You normally wear a body camera.
Every shift.
And you also have an in-car video.
Yes, ma'am.
When you brought this case to the DA's office, did you bring copies of those body cameras?
On the old software, they are downloaded onto DVD disc, and they should have been with that grand jury packet, yes.
And do you download those or a supervisor?
A supervisor does.
Okay. So you didn't bring DVDs with this packet, is that right?
To my recollection, I'm not sure.
Okay. Would you remember marking the grand jury packet sheet?
I remember marking DVD request submitted, and I remember submitting that to my sergeant.
Okay. So what does that mean?
That with the old body camera footage, the body cameras are required to be docked via USB cord into the docking system. After
So
that,
you have to physically take it off and plug it into the
yes,
computer?
ma'am. We did that every shift. After that, the car camera videos are downloaded onto an SD card that are inside the dash camera. Those are taken out and swapped with an empty SD card every 2 weeks when we do our time cards and pay periods. Those are also provided to the sergeant, and those get downloaded into the software.
With all those moving parts, is that the same body camera and car camera system that the police department uses now?
No, ma'am.
About when did that transition take place from the old system to the new system?
2023, I believe.
Why did the police department change body camera systems?
Our digital ally system was having problems with corrupting files and losing the camera footage.
Did you intentionally destroy or have anyone else destroy the body
ma'am.
camera?
Okay.
So there is no body camera available today.
No, ma'am.
We don't know if it was human error or computer error.
Do not know, no.
Why did you charge the defendant with false imprisonment?
Due to Miss Bethany's statement about him holding the door shut and preventing her from exiting the store, taking away her liberties of escaping the store.
So by false imprisonment, you don't mean that he tied her up.
No,
You mean he prevented her from having a clear path to exit.
correct.
The defendant, as you spoke to him, did you smell the odor of alcohol on him?
I did.
You did?
Yes, ma'am.
Okay, are we talking a little bit, a lot? Could you elaborate?
To my knowledge, I don't know how much. I do know that the odor of alcoholic beverage was present on his person.
Why did you charge him with disorderly conduct?
With Miss Bethany's statements, along with the person being there in the picture of the still shot of the camera footage, causing a public alarm.
Did he ever hit Bethany Page?
No, ma'am.
Why did you charge simple assault?
He, according to Miss Bethany's statements, with him threatening to beat her up, the opportunity and jeopardy was there at the time. And she said she was placed in fear.
Judge, at this point in time, I'll pass the witness.
Vaughn, you may cross-examine.
Afternoon, Mr. Wolfe.
Can you recall how long ago this incident was?
3 years ago.
Okay, 3 years ago. Was it summertime, wintertime?
The technical term, I believe, still summer,
Still summer.
with it being August.
You seem like you got a very vivid memory of what happened. Would you please explain to me how?
My police report.
Your police report. Okay. You stated also that there was an issue, there was errors with your body cams possibly, correct?
Correct.
Okay. Was there also some issues with your patrol cam?
It was all in one software. The issue wasn't with the cameras themselves. The issue is with the software at the department.
Okay. Was there any issues with the Exxon cameras?
We did not have Axon cameras at the time.
No, I'm talking about, I know
Oh, the
you
Axon.
didn't.
Oh, I'm sorry. Our new body cameras are called Axon, so I thought that's what you said.
Okay, that's nice. to
You're
know.
saying the Exxon gas station.
Yes, sir.
Not to my knowledge.
Did you happen to get a copy of these pictures?
I did not.
May I ask why?
I believe I wasn't able to get a copy at the time.
Was there anybody else present at the scene when you got there?
At which scene? The Exxon or the
Let's say
Defense Auto
witnesses
Parts?
per se. Any witnesses per se?
Witnesses, i.e., are you talking other law enforcement officers, or are you talking just citizens?
And citizens or law for anybody? Just
Off the top of my head, no.
okay. So you weren't the first to arrive at the scene, were you?
No, sir.
So all the information that you received is from DTF or Miss Bethany, correct?
Correct.
Not firsthand knowledge?
No, sir.
Okay. You stated that you charged me with a public alarm. This was because of a picture you
That's
seen?
disorderly conduct.
Of disorderly conduct. This was because of a picture you seen?
It's based off of Miss Bethany's statements, along with her sequence of events, and then that picture she showed me with the customer being in that picture is why I charged you with that,
So
causing a public alarm.
and how would you describe how it looked in the picture?
Off the top of my head, I cannot. I know in my report it notates your hands were up in the air.
Does that technically mean like I was being aggressive, violent, threatening, public alarm? Does that mean that?
It would coincide with the mannerisms of someone who's in upset attitude, but I cannot say for sure.
How would you say my attitude was when you encountered me?
I don't think you were happy dealing with law enforcement.
Okay. After hearing Miss Bethany's statements today, would you say they're about the same as they was the day you arrested me?
Not all the way, but it has been 3 years.
Okay. When you were speaking to Miss Bethany, would you believe that she was in fear?
I did.
You did. Did you notice any other doors inside the Exxon?
I was not paying attention.
Okay. And when you encountered me, where was I at?
The Advanced Auto Parts store.
Would you say, how long would it take you to get to this scene?
From
From where you were? Well, I don't know when you received the call, but how long would you technically take to get to this scene?
couple minutes.
Couple minutes. So it wouldn't take you 10 minutes?
No, sir.
Okay. What about DTF? You think it took them about 10 minutes?
I do not believe so. I know they were nearby. Their exact location I'm unaware of.
They got there before you too?
Correct. I do remember being down south, and if you're not familiar, down south is our southern jurisdiction area of our city, is towards like the interstate. I was not all the way at the interstate, but I was in that zone.
Okay. So you say, what is your typical response time if someone made a call?
A
About
couple minutes.
a couple minutes, being 2-3 minutes?
Couple minutes.
Okay.
Unless it pops up right next to me.
Did you hear that I was driving irate or anything?
Not driving, no.
Trying to get away from a scene or something? Seemed like I was running from anything?
Nope.
You think if I was running from something, I would go to Advanced Auto Parts next door? Okay. There was no other witnesses on the scene?
Not to my knowledge.
None to take witness statements from?
Well, not to my knowledge, but at the same time, if a witness doesn't want to provide a statement, they don't want to be there and cooperate, they don't have to.
But if your body cam was on, that would corroborate with that, correct?
Correct.
Okay, what about Miss Bethany? Did she make a witness statement that night?
She did not.
Okay, what about the DTF? Did they make a supplement witness statement?
They did not.
Okay, you said you felt like Miss Bethany was in fear. What is your normal procedure with dealing with somebody that's in fear of another person?
Would you elaborate?
Um, how would you comfort the situation, or how would you address the situation of someone? If I told you I was in fear of this person right here, how would you address that?
I'd ask you how they made you in fear.
Okay, I told you I was just scared, and you come to the conclusion that it was an assault you're going to charge the person with, what would you do then?
Well, in that situation, if we're going to talk about that, if she's saying she's in fear in a public setting when there's other people around, that constitutes a public alarm mixed with the opportunity and the jeopardy being there with you saying, I'm going to beat your, quote, ass, then that would constitute an assault could have occurred.
Okay. So did you hear me make these statements?
No,
You got any proof of these statements?
Miss Bethany.
That's your only proof?
Yes, sir.
You believe her to be very truthful?
That is her testimony. She swore to it.
Okay, do you believe it to be truthful?
I do.
Okay. So someone that tells you that they're scared, what do you do after you arrest someone? What is your normal procedure? Do you have a victim statement you give them? Do you notify them that they can put a restraining order on someone? Or, do you just let them go on about their lolly-dolly way? You don't have to make a statement or nothing?
For domestic violences, yes, but not just simple assaults, no.
Someone that says they're in fear, wouldn't you make a record of that other than just arresting a person?
That's what the police report's for.
Just so she don't need to make a statement?
She don't want to.
Did she want to, or did you not give her that
I
option?
cannot recall.
Okay. Have you ever been inside the Exxon?
A couple times, not a lot.
Is there another way into the Exxon besides the front door?
I'm not sure, honestly. I don't frequent that store a lot, so
Okay. You're not for sure if there's a door into Crystals between
not
them?
to my knowledge, I'm not sure.
Okay.
No offense to her, but kind of not a good gas station, so I stay away from
I
it.
agree. Okay, let me see. So everything that you're basically telling me you put in your report was not firsthand knowledge you received from other officers that was on the scene prior to you. You stated that you didn't think I was too irate when you got there, did you?
You were not happy. I will say that. You were not acting normal.
What's that mean? Would you use your own words?
Upset, I would say. You weren't talking like this.
Okay. Was
Yeah.
I screaming, ranting, raving?
You're a little louder, yes.
Was I screaming?
Off the top of my head, I can't remember, but I remember it wasn't like this.
Was I ranting and raving?
I can't remember.
Was I free?
Free.
Well, I mean, was I in handcuffs?
At one point, you ultimately were put in handcuffs, yes.
And where was I placed?
Later on in the back of my patrol vehicle.
All right, thank you. No more questions.
Senator Bryson, redirect.
Let's clear up a few things. When you got to the scene, were there any other customers in the store?
Off the top of my head, I'm not sure, but I do remember that picture of the security camera footage. There was a customer standing there with them.
If there had been customers in the store, would you normally have spoken to them?
Yes, I would have.
So if your report doesn't indicate you talking to any customers, is it most likely that there were no customers at the store?
Very well could be.
In fact, usually if there are people on scene, you take down their information.
Correct.
So if we look at your report, you would have down the defendant's information, his girlfriend's information, Miss Page's information. Would it help refresh your recollection to see if there any other information you took down that night?
It would. Okay.
Okay, will you pass that back? Did you notate that there were any other customers on scene when you arrived?
No.
Let's see, you were asked if you had any firsthand knowledge. Let's clarify that. You had statements from the defendant, right? And Miss Page. And then you also looked at the still photos from the surveillance. Would you say the still photos aligned with what Miss Page said or contradicted it?
I would say they align with it.
Okay. And then we've been throwing around the term witness statement. Miss Page did not write you a written witness statement,
No, ma'am.
right?
No, ma'am.
But she talked to you.
Correct.
Would you say she talked to you freely?
Correct.
Did she answer any questions that you had?
I would believe so, yes.
Okay. So she did give you a statement. She just didn't write one down.
Correct.
And the same, you spoke to the officers that were on scene, the drug task force officers.
Correct.
Okay. Even made notes in your report about what they told you.
Correct.
So they didn't write a statement, but they still gave a statement. Would you say
Correct.
that's correct? All right. Nothing further, Judge.
Anything else, Mr. Vaughn?
So, you stated that there was no other witnesses. That just seemed correct.
Off the top of my head, I do not know. However, there is none notated in my narrative or in the witnesses tab of my report.
Okay. I'm still just mind boggled about the fact that
Judge, objection. Let's keep to questions and not statements.
she didn't let me ask the question.
Well, you were making a statement. What is your question?
I'm still mind boggled about the fact that you were at the scene and you didn't have nobody write a statement. How is that possible?
At the time, I had a body camera on as well.
The body cam that didn't work,
At the time, it was working, yes.
but earlier you stated it was error, so it was
Later
working at the
on,
time.
I can't predict the future, so.
Okay. That'll be all, Your Honor.
Anything else from this officer?
Did you believe that your body camera was recording the events of that night?
Yes,
And had you not had a body camera or not known that it was having issues or whatever, would you have handled the situation differently?
correct.
Yes, ma'am, I'm sorry. Had you not been wearing a body camera, or had you known that we would have issues having a copy of the recording, would you have handled the situation differently?
Yes, ma'am.
How would you have handled the situation differently?
In that term, I would have first, if it was a problem with the body camera while on scene, they had a visible red light illuminated whenever they're on and recording. If it had been dead or non-functioning at the time of the scene, I would have went into my car and swapped the battery in it to see if that fixed the problem and make sure it was recording at the time. If I knew I didn't have a body camera, or if I knew it was going to mess up, I probably would have went the extra route of writing statements, yes.
So you had a means on the body camera to see that it was working while it was recording?
Correct.
So it recorded that night, we just don't have the recording?
Correct.
Nothing further, Judge.
Mr. Vaughn, anything?
Yes. You stated you would have handled it different if you known your body cam wasn't working.
Correct.
What is the relevance to that? Like, would it have changed the fact that you didn't get a witness statement for everybody at the scene, including your fellow officers?
Well, like I said before, if a non-officer civilian witness does not want to write a statement, I can't force them to. I can ask, but if they don't want to, I can't force them to. The fellow officers with the drug task force I work with and alongside, so I can just get their statement from them personally. And if I need be, if I wanted them to write a supplement, I could have asked them.
You didn't feel the need to get them to write a supplement for you when you weren't the first person on the scene?
No, sir.
Wouldn't it be more adequate to do it?
At the time, no, because I had my camera footage.
Let me ask you this. You stated that you also felt like I was under the influence of drugs, correct? Or alcohol, or whatever the case may be.
Alcohol, yes.
Okay. Did you give me a field sobriety test?
No.
Did you get my blood drawn that night or anything?
No.
Did you give me a breathalyzer test?
City of Dixon doesn't use breathalyzers.
So there is nothing that you can possibly prevent to this, show the court today that I was drunk or under the influence or anything, is there?
My testimony that you had the odor of an alcoholic beverage emitting from your person on that afternoon mixed with my training and experience.
So your training and experience, I mean, you could just speculate?
If you can smell the odor of alcoholic beverage emitting from someone's person, it's usually due to them consuming it.
Okay. Was there anybody else at that scene tonight with me, maybe?
Your girlfriend?
Okay. Was she under the influence of anything?
I do not recall.
What about Miss Bethany that night? Do you know if she was under the influence of anything?
Not to my knowledge.
Okay. That's all I have, Your Honor.
All right. Thank you, Officer. You may step down.
Thank you.
General Bryson, you may call your next witness.
The state's proof, Judge.
State has rested their proof. Ladies and gentlemen, if you'll step across the way to the jury room, then let me take up a matter and then we'll come back to you.
Sorry, you can ask for your water. I don't know.
Respond, the state has rested their proof, and as you know, as we've been through this before on a couple of other occasions, it now falls to you to decide whether or not you want to testify at this trial. Do you wish to testify today? You have the right to call witnesses, and I know you have a witness here. Do you want to call your witness and offer her a testimony?
Yes, Your Honor, but I also have a question too. I know this is a state's, whatever you want to call him, but at the same time, he's a witness in this. For him to be present a full time, wouldn't that be kind of unfair on my behalf?
I'm sorry, what?
I mean, he's a state's witness, and he's also, what do y'all call him else? He got two titles a day. The state's designee or whatever. I mean, wouldn't that be unfair to the defense to have him sitting through the whole proceedings and giving testimonies after hearing other witnesses?
Well, it may be considered to be unfair to you, but it is the rule that allows the state's designation of a law enforcement officer in a criminal case to be seated at a table and to be present during that. They're exempted from the rule, a specific rule, a specific provision of the rule allows the state to designate a law enforcement representative, and that person can remain in the courtroom. So whether it's fair or unfair in your opinion, it is permitted by the laws. Now, the next question is, do you want to put your witness on the stand and then decide whether or not you want to testify, or do you know at this point where you want to testify or not?
Let's put the witness on the stand.
All right, we're going to take about a 10-minute recess, and then we'll come back and let the jury know we're on recess for 10 minutes, please. We'll stand in recess for 10 minutes.
All rise.
Right. We are ready for the jury to be brought back. All right, thank you, ladies and gentlemen. The state has rested. Mr. Vaughn, do you wish to offer any witnesses or proof?
Yes, Jennifer Dozier, please.
All right. Ms. Dozier, if you'll come up, please. Raise your right hand and be placed under oath. All right, Mr. Vaughn, it's your witness, so you may question the witness.
Yes, sir.
Vaughn, you may ask.
Okay. How are you doing?
I'm okay.
Okay. For the courts, would you tell them how you know me?
You are the father of my kids. We've been together on and off for 20 years.
Okay, are we together now?
Not currently, no.
How long have we been separated this time?
Little over a year.
Okay. You mad at me or something?
No.
The reason I'm asking, do you have a reason to be vengeful, or you want to answer truthfully here today?
Truthfully, I just didn't agree with, we didn't see eye to eye on things.
That's irrelevant.
Okay.
We didn't agree with our lifestyles.
Okay. Okay, do you recall what we stopped at the Exxon for that night?
Can of dip.
Did I get that can of dip?
No, you did not. That was most expensive can of dip.
I didn't get the can of dip.
No, you didn't.
Oh, darn. Have you been inside the Exxon before?
Yes.
How many doors are there in the Exxon?
There is a door directly in the front of the Exxon, and then a door that conjoins with the crystals, and they actually have a door in the front as well.
Okay, so there's multiple entrances and exits into the Exxon?
Yes.
Okay. Did you witness anyone threatening anyone that night?
Well, no, I didn't witness the threatening. Or any
Did you?
threatening.
Man, put the microphone
All right.
right up against your mouth there and
What?
speak loudly, please.
Okay, did you witness anyone threatening anyone that night?
No, I did not.
Okay. Did you witness anyone being hit?
No, I did not.
Okay. Didn't you witness anyone else present at the scene when we were at the Exxon?
No, there wasn't a lot of people at the Exxon.
Not a lot of witnesses? Okay. When we left the Exxon, did we leave in a hurry or?
No.
Okay. Where did we park at the Exxon when we was there?
Seems like you parked right in front of the store.
Is this my normal place to park?
Yeah. Everywhere.
What do you mean by everywhere?
Oh, come on.
For the courts, please.
You just, yeah, you don't like parking and having to walk, so you park right on the store, like right at the store every time.
Okay. So when we left the Exxon, Was it any, we weren't running from anything, were we?
Not, no.
Where did we go when we left the Exxon?
2 businesses down to the Advanced Auto Park.
Would you believe that I was irate that night when I was driving away from Exxon?
No, I think you were actually kind of laughing a little bit.
Okay. What did we do when we got to Advanced Auto
We
Parts?
went in and got a car part for our boss's derby car.
Okay. How would you say my attitude was then?
Fine.
Did you see my attitude change at any time during that night? Okay. When did we have a altercation, or let's say, not altercation, but the word I'm looking for? When did we make first contact with the officers?
The officers at Advanced Auto, after we were already in the store getting the part.
Okay, so we didn't run into the officers basically until we exit the store.
Yes.
Okay. Do you know a Miss Bethany Page?
No, I do not.
How often would you say that I went to Exxon?
Not often. It wasn't a regular store.
Okay. Would you state what side of the town our regular store would be?
Pomona,
Pomona. Why would that be our regular store?
because that's where we lived.
Okay.
For 20 years almost.
Okay. And you don't know Bethany Page?
I do not.
She don't know you?
Not to my knowledge.
Would you be able to pick her out if you've seen her?
Absolutely not.
Do you believe, to the best of your knowledge, that I know a Miss Bethany Page?
Not to my knowledge, no.
That I'd be able to pick her out if I ever seen her?
Not that I'm aware of.
Okay. Let me see. Any more questions for you? Did I exit the store with anybody? Did you see anybody at the store?
No, I mean, she came out right after you.
She came out of the
She
store?
did come out after you, yes.
Did you see her body language or anything?
It seems like she was kind of yelling a little bit and you kind of laughed at it.
Okay.
Oh well.
Do you feel like she was scared?
No.
Okay. Did you see her with a phone or anything in her hand?
No, I wasn't looking really at her hands.
How long would you say that the time lapsed from the time we was at the Exxon to Advanced Auto Parts?
Couple minutes, if that.
Okay. Would you believe that someone that wants to harm somebody would go next door to Advanced Auto Parts?
It doesn't seem very smart.
Do you believe that my actions that night were to do anything to get a part? But get a part for a derby car?
No.
Okay. I think that's all my questions I have, Your Honor.
All right, General Bryson, you may cross-examine the witness.
Did you get out of the store at the Exxon?
No,
Or did you
ma'am.
get out of the car at the Exxon?
No, ma'am, I was in the car,
Okay. What were you doing in the car?
just waiting.
Scrolling your phone?
No, just waiting, just sitting there, you know.
Were you paying extra attention to what was going on in the store?
Whenever I seen him come out and then her come out, that's when I noticed, like, hey, you know, and then she said she was scared. Why would you follow him out of the store if you're that scared? I'm gonna call the police. I'm not gonna
So
go
you,
out.
you didn't look, you didn't pay any attention until they both came out of the store?
Yeah.
Okay. And you would call the police if you were scared?
Yes, absolutely. I wouldn't go out with him. I'd be like, go out the door, lock it.
Okay. Did you observe if any other customers came in and out?
Not to my knowledge, no. I didn't
Okay.
see anyone.
Were you staring out the front window, watching
Yeah,
traffic?
well, he parked kind of like facing the auto parts store, like straight in front of the store with the front towards Crystal's. So when he come
Okay.
out, I seen that because I was in the passenger seat.
So when he pulled up to the store, you're in the passenger seat. Was the passenger seat beside the gas station or the driver's seat beside the gas
The
station?
passenger seat,
And I say gas station,
the front
not the
door.
pumps, but
Yes,
the
ma'am.
building.
It
Okay.
was mine, the passenger.
Have you ever heard Mr. Vaughn yell?
I'm with him on and off 20 years. I've heard him yell.
He can get pretty loud,
He
can't
can. Any people don't know how to take him.
Okay. Nothing further, Judge.
You redirect?
Yes, sir. You stated that you were in the vehicle,
I was.
and the vehicle was pointed towards Advanced Auto Parts Crystal's direction, correct?
Yes.
Would you say your door, the passenger door of the vehicle, would you say it was directly in front of the Exxon door?
Pretty close.
All right, here's a real good question for you. So why did I go to the Exxon?
For dip.
And I went into the Exxon. How long would you say that I was in there?
Couple minutes.
Did you see which direction I went when I went in the Exxon?
And went around the back of the vehicle.
No, I'm talking about when I entered the store.
Oh, I don't remember that part. I'm sorry.
Okay, you couldn't see the counter?
No, I wasn't paying attention to the counter, to be honest. I mean, you don't pull up at the store and expect,
Would you say I was in the store just 10 minutes, maybe?
No, it wasn't even 10 minutes.
15 minutes?
No, maybe 5 to 7 minutes.
Did I exit the store with anything?
I don't remember. I don't think you did.
Okay, let's see. That's all, Your Honor.
Recross?
You knew that the defendant went into the store to get dip
Yes.
and that he came out of the store without dip.
Well, I seen him coming out and her coming out behind. Because at that point, I kind of heard a little bit. And I was like, doing over there, So
What'd you hear?
I don't remember. This has been years ago. I just heard her screaming and he was kind of chuckling and coming around the bar. I don't remember what was said.
Did you ask why he didn't buy dip?
Yeah, and we had discussed it. And
What did he tell you?
he got into an argument because Miss Bethany thought that she knew me and apparently wanted to fight me. So he was trying to stop her from coming out to have an altercation with me.
Okay. Nothing further, Judge. Did you know Bethany?
I did not. It was a very bad case of misidentification.
Did you think you knew her that night?
I thought I knew her from school and from younger days.
What did you think her name was?
Jessica,
Nothing further, Judge.
Go on.
The state seems to want to have the court believe that I went to the Exxon for a Jessica. Would you say that I went to,
Let me rule on the objection. Sustain the objection. You're making a statement rather than a question.
let me rephrase it for you. Did I go to the Exxon looking for a Jessica?
no, you did not.
Do I know a Jessica?
Your cousin's wife, but I don't think that one matters.
That works at the Exxon, I could say.
Not to my knowledge.
So I went to the Exxon for what?
Dip, strictly dip.
Did I go looking for trouble?
No,
Do I know anybody that works at the Exxon?
no,
Did I give any indication that I wanted to go to the Exxon for trouble?
no.
You stated that she followed me out the store.
Yes, you did.
What would you think the reason for her following me out the store would be?
Anger?
Sustained.
You said, what was she doing out the store?
Be the
Yelling?
same Are you asking what actions she was doing
Yeah,
outside?
yeah,
I mean, I just seen like the yelling and the hand motions.
okay. No police showed up at this time?
Not at the store, no.
Was the police called at this time, of your knowledge?
No, they were not.
Okay. That's all I have, Your Honor.
General Bryson, you have recross. Thank you, ma'am. You may step down. Mr. Vaughn, you may call your next witness. Ladies and gentlemen, step across the way just for a moment, please. Vaughn, you need to let the court know whether or not you plan to testify or not so that I can conduct what we call the Momon hearing as to whether or not you wish to testify. Come up to the podium. Come to the podium, please. Raise your right hand and be placed under oath.
I just affirm.
Mr. Vaughn, do you understand you have a right to testify if you choose to, and that if you want to testify, no one can prevent you from doing so?
Yes, I understand.
You understand that you also have the absolute right not to testify, and that if you don't want to testify, no one can force you to do so?
Yes, I understand.
You understand that you're acting as your own lawyer, so you are required to make this decision on your own behalf. You understand that?
Yes, I understand.
At this point, the next step would be if you have any other witnesses, including yourself, to testify. So I need you to tell me, do you want to testify at your trial or not?
May I ask a question about that, Your Honor?
You can ask a question about it, yes.
How do I testify at the trial for myself? Do I write questions down and give them to you, or
No, you just take the stand and then you testify, you state, you're placed under oath, and then you state what you want the jury to hear as far as your version of these events, and then the state has the right to cross-examine you.
Okay. I'll testify, Your Honor.
You will.
Yeah, I'll
All
testify.
right. Then we're ready to bring the jury in.
Jury, the state filed a notice of impeachment before trial. It was filed in March of 2023. A copy was given to Mr. Flanagan and Ms. Coffenberry, who were attorneys for the defendant at that time. The same was provided to the defendant when he was mailed discovery. I would ask for the court's ruling on which of those convictions will be admissible to ask him about.
But what day did you file that?
March 23rd, 2023.
You have a copy that you can provide to the court without me having to look through?
I do.
Mr. Vaughn, the state has filed a notice of impeachment and range of punishment as they are permitted to do under the law that states that if you were to testify, they are asking that they be allowed to introduce the following for impeachment purposes: that you were found guilty in the Circuit Court of Dixon County in docket number 2015 CR 114 of aggravated assault, a Class C felony, and received a sentence of 3 years on November the 18th of 2016. Second, that you were found guilty in Circuit Court in docket number 2015 CR 134 of evading arrest, a Class C felony, and received a sentence of 2 years. And that was November 18th of 2016. that you were found guilty of the Circuit Court of Dixon County in docket number 2015 CR 199 of aggravated robbery, Class B felony, and received a sentence of 8 years, November the 18th of 2016. That you were found guilty of the Circuit Court of Dixon County in docket number 2015 CR 200 of aggravated robbery of Class B felony, and received a sentence of 8 years, November the 18th of 2016. You were found guilty in the Circuit Court of Dixon County, Tennessee, in docket number 2010 CR 706 of aggravated assault, a Class C felony, and received a sentence of 3 years on July the 15th, 2011. And finally, that you were found guilty in the Circuit Court of Cheatham County in docket number 16001 of failure to appear, a Class E felony, and received a sentence of 2 years on April the 27th, 2010. Those are the offenses that the state intends to cross-examine you about and bring that out, because it is permissible to cross-examine someone on a charge, rather who is testifying, by showing that they have felony convictions. I'll be glad to hear you if you want to argue against the introduction of those.
Yes, Your Honor. The relevance to this case, they have no relevance. I didn't harm anyone. There's nobody physically harmed. As you can see, all them cases are very violent. There was people actually touched in those cases. This is just some he said, she said. That's not the case here. I mean, you know what? Forget all that. How about this? I don't testify. I ain't got more time for this. Let's finish this. I ain't gonna keep going back and forth with y'all. This is crazy.
The law permits the state to impeach a witness by the introduction, or anyone to impeach a witness by the introduction of felony conviction, so long as those convictions are not related specifically to the type of case that we have here. Having explained to you what the state's intents are, now you have decided, if I understand correctly, and you state under oath that you desire not to testify. Am I correct?
Yeah, ain't no point in it. It's a monkey show, bro. Straight kangaroo court in here.
Vaughn, I have treated you with, let me have another form, please. I've treated you with as much respect as I can do for it, as I would any other criminal defendant, even though you're representing yourself. You can make that kind of insulting statement all you want to. It will not change the outcome of this court, nor will it affect this court's ruling on matters that are between, or that are within my. Let me have one more. I'm gonna have to quit talking more. And this to Mr. Vaughn, this is that waiver of your right to testify. You've been given your right. Is that squiggle line your signature? Is that the only signature you ever use?
You can use it.
I can use it. I don't care if I.
I know you can. You just use the signature I gave you.
Let the record reflect that the defendant has handed to the court a waiver of right to testify, and that he executed that in this courtroom on the 23rd day of October 2025, and that the signature line appears to be just be a squiggly line. It does not bear the same signature as he has on many multiple motions that he has filed, but I will accept this as his signature and his waiver of his right to testify. All right, then we are ready to bring the jury back. General Bryson, I'm about to have the final charge printed. Again. And you've got that. Thank you. And I'll give you back. Did you put it in this one? Is this one correct? All right, Mr. Vaughn, do you have any other witnesses you wish to call?
No, that'd be all, Your Honor.
All right, state have any rebuttal proof?
No, Judge.
Then we will move to closing arguments. General, you may address the jury.
Judge, I would ask that the victim be allowed to come back in for closing arguments.
All right, she may be allowed to resume presence in the courtroom. General Bryson?
Thank you, Judge. Ladies and gentlemen, thank you for your time and attention on what turned out to be a very long day. You were called in to hear the charges against the defendant of simple assault, false imprisonment, public intoxication, and disorderly conduct. The state presented to you direct evidence, which is the judge gave you in your first jury charge. It's proof of a fact such as the testimony of an eyewitness, and you heard that proof from Bethany Page. This incident was so significant in Miss Page's life and in her work that she called 911 from the store there. She didn't call the non-emergency number. She didn't call her boss. She called 911 because she was afraid of what would happen. She told you that between the defendant's shouting, his waving his arms, his pulling his hands back as if he might hit her, his actual statement that he was going to beat her up, that she was afraid. That is charged under Tennessee law as a simple assault. So to give you a bit of a legal background, once upon a time, assault and battery were two separate offenses in the state of Tennessee. Assault being the fear that someone would hit you, and battery being someone actually hitting you. Tennessee has charged that under one statute, which is simple assault. And the state is proceeding under the theory that she was threatened, that she felt threatened, she felt like she could be hit, she felt like she was in danger of imminent bodily injury. So if someone is to call over the phone and say, I'm going to hit you, there is no imminence. They can't do it immediately. Mr. Vaughn was across the counter from Bethany Page when he told her he was going to beat her, and he made drawbacks as if he might. It was during that time customers came in back and forth. He would calm down and then ramp back up, continuing to yell at Miss Page, continuing to call her names, continuing to make a scene in the store. And I need that other. Let's talk about the disorderly conduct. So the court is going to read you the law on that. And one element, the first element, is that the defendant was in a public place. The Exxon is a place that is open to the public. Now, why this is charged in addition to the simple assault is because the effect of the behavior on the public around. When you commit an assault in the public, it can qualify also as that disorderly conduct. So the defendant was in a public place with intent to cause public alarm or public annoyance, and he engaged in fighting or violent or threatening behavior. And he acted either intentionally, knowingly, or recklessly. Those are the elements that you have to find the disorderly conduct charge. Okay? So we've presented proof that while in a public place, the defendant was not only saying he was going to hit Miss Page, he was acting as though he was going to hit Miss Page. Now, as for the public intox, witnesses testified that they could smell the odor of an alcoholic beverage on him, and Miss Page testified specifically that she remembered seeing his bloodshot eyes. Public intox, it is not a crime to smell like alcohol in a public place. You combine that with the rest of his behavior, that the defendant was under the influence to a degree that either the defendant may have been endangered, he may have been endangering others, other people or property, or that he unreasonably annoyed people in the vicinity. And again, that he was in a public place, acting either intentionally, knowingly, or recklessly. Now, the false imprisonment sounds like he would have had to tie Miss Page up. It is enough that he blocked her path to the exit. There is some testimony that there was another door to the building, that the door was locked. This would be, this would require the victim to jump through hoops, that she would get the key, that she would go unlock the door, that she would take that other path. Where here you have the victim saying that she was trying to see where he was leaving, where he was going, and he was blocking her path to exit. You also have that while she was behind the counter, he kept coming up, blocking her path to exit. She was trapped in that space behind the counter. So you have more than enough proof to find there. You have testimony from the officers indicating that he was still, kind of upset when they got there, even though he had relocated to a different store, didn't like interacting with the officers, didn't want to identify himself, generally just being disagreeable, which is a carryover from his behavior with Miss Page. This is not a homicide case. This is not an aggravated assault case where a weapon was used. But this was still a significant day in the life of Bethany Page, to where she picked up the phone and called 911 because she was in fear for her safety. And you are faced to look at the charges that were put before you and decide if the proof today meets those elements. And if you think that they meet those elements, then I would ask you to return a guilty verdict on all 4 charges. Thank you.
Mr. Vaughn, do you wish to address the jury?
Yes. How y'all doing? Y'all have heard the evidence from the state. You heard evidence from my behalf. Them sound like 2 different stories if you can hear what I'm hearing here today. State is making statements that the woman was blocked behind the counter. I never heard that here today. I've heard that she freely walked me out the door. I also heard the woman state that I was in the store for 10, 15 minutes talking to other people. Doesn't seem like someone too scared right there. Also heard she made a statement of calling 911. It doesn't take 911 10 or 15 minutes to get to Exxon. It's in the middle of town. DTF showed up. Dixon PD showed up. I wasn't even at the scene. Excuse me, I have a piece of paper I want to read to y'all. Let's talk about the false imprisonment. You've heard that the witness state that I blocked her path outside the store where my truck is parked. I don't see that really blocking a path if I'm already parked in front of a store. You also heard the witness say that she locked the door to the other side, and she never did state that she didn't have keys to open that door or had to go get them. If someone's in a store for a while, I don't see any way possible for someone to be harmed. If they wanted to harm them, they can possibly harm them. Let's talk about the public intox. You can blame red eyes on anything. There is no proof that the state can provide, Ms. Bethany, nor the testifying officer, that there was any public intox. There was no breathalyzer test. There was no field sobriety test. There was no blood drawn. No nothing that they can provide other than their statements here today. Let's talk about this public alarm. This is a TCA statute. It's 40-7-103. Grounds for arrest by an officer without a warrant. An officer may, without a warrant, arrest a person for a public offense committed or a breach of the peace threatened in the officer's presence. I've proved here today that nobody was present. There was not an officer present. There was just me and Miss Bethany in the store. It's virtually my word versus hers. She has no witnesses on her side to back her statement. I have no witnesses on the side to back mine. It's he says, she said, like I told y'all from the beginning. If I went all the way to Advanced Auto Parts store. If I really wanted to harm someone, I believe that was in my well means to do so. Standing in the store for 15 minutes, parked in front of the store for however long that was, and not even a rock throw away at the Advanced Auto Parts next door. There is no public alarm when the officers didn't witness it. There is no public intox when you have no proof to provide that there was intox. There is no false imprisonment standing outside of a door. There is no assault when I'm standing in a store talking to someone, as the victim themselves stated I was, and then freely of my own will leave the store. And just, it's the fact that the memories of everybody, from the officers to all the witnesses here today, are not, they're very vague. 3 years is a long enough time for anybody. To actually believe that these charges I should be found guilty of, I believe there's enough evidence to believe that I shouldn't. And I want to thank y'all. Have a good day.
Bryson, you have the final say.
I'll waive rebuttal clause, Judge.
All right, ladies and gentlemen, then it's time for me to charge you, give you your final set of instructions. You will pass that to the jury. All right, ladies and gentlemen, this will be the final charge of the court. Ladies and gentlemen of the jury, the defendant, Sherrick Vaughn, is charged in the indictment in count 1 with the crime of assault. In count 2, the defendant is charged with false imprisonment. In count 3, the defendant is charged with disorderly conduct. In count 4, the defendant is charged with public intoxication. The defendant pleads not guilty to each and every offense embraced in the indictment. The evidence and arguments in this case have been completed, and it is my duty now to instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out one or more of them to the exclusion of another or others, but should consider each one in the light of and in harmony with the others. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial and is not overcome unless from all of the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts, but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. Reasonable doubt is that doubt created by an investigation of all of the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required. And this certainty is required as to every element of proof necessary to constitute the offense. The state must prove beyond a reasonable doubt all of the elements of the crime charged, that the crime, if in fact committed, was committed by this defendant in Dickson County, Tennessee, and that it was committed before the finding and returning of the presentment in this case. The burden is upon the state to prove by a preponderance of the evidence that this offense was committed in Dickson County, Tennessee. Proof by a preponderance of the evidence means that the greater weight of the evidence must be in support of the state's contention. Venue of the offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by a preponderance of the evidence that this offense was commenced or consummated in Dickson County, Tennessee, then you must return a verdict of not guilty. As heretofore stated, in count 1, the defendant is charged with the crime of assault. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant caused another to be in reasonable fear of imminent bodily injury. 2, that the defendant acted either intentionally or knowingly. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. If you find the defendant guilty of assault as charged in the indictment, you shall so state. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt, then you shall acquit the defendant of this offense and proceed to count 2. As heretofore stated, in count 2, the defendant is charged with the crime of false imprisonment. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant removed or confined another unlawfully so as to interfere substantially with the other's liberty. And 2, that the defendant acted knowingly. A removal or confinement is unlawful if it is accomplished by force, threat, or fraud. Although the law requires no specific time period of confinement or distance of removal, a removal or confinement interferes substantially with another's liberty if the time of confinement is significant or the distance of removal is considerable. To find the defendant guilty of this offense, you must also find beyond a reasonable doubt that the removal or confinement was to a greater degree than that necessary to commit the offense of assault as charged in count 1. In making this determination, you may consider all of the relevant facts and circumstances of the case, including but not limited to the following factors. A, the nature and duration of the alleged victim's removal or confinement by the defendant. B, whether the removal or confinement occurred during the commission of a separate offense. C, whether the interference with the alleged victim's liberty was inherent in the nature of the separate offense. D, whether the removal or confinement prevented the alleged victim from summoning assistance, although the defendant need not have succeeded in preventing the alleged victim from doing so. E, whether the removal or confinement reduced the defendant's risk of detection, although the defendant need not have succeeded in this objective. And F, whether the removal or confinement created a significant danger or increased the alleged victim's risk of harm independent of that posed by the separate offense. Unless you find by a reasonable doubt that the alleged victim's removal or confinement exceeded that which was necessary to accomplish the alleged assault and was not essentially as incidental to it, you must find the defendant not guilty of false imprisonment. Force means compulsion by the use of physical power or violence. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to the results of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to the result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. If you find the defendant guilty of false imprisonment as charged in the indictment, you shall so state. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt, then you shall acquit the defendant of this offense and proceed to count 3. As heretofore stated, in count 3, the defendant is charged with the crime of disorderly conduct. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant was in a public place and with the intent to cause public alarm or public annoyance. And 2, that the defendant engaged in fighting or in violent behavior or threatening behavior. 3, that the defendant acted either intentionally, knowingly, or recklessly. Public place means a place to which the public or a group of persons has access and includes but is not limited to highways, transportation facilities, schools, places of amusement, parks, places of business, playgrounds and hallways, lobbies, and other portions of apartment houses and hotels not constituting rooms or apartments designed for actual residence. An act is deemed to occur in a public place if it produces the prescribed or offensive consequences in a public place. Intentionally and knowingly have been defined in count 1. Recklessly means that a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessness is also established if it is shown that the defendant acted intentionally or knowingly. If you find the defendant guilty of disorderly conduct as charged in the indictment, you shall so state. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt, then you shall acquit the defendant of this offense and proceed to count 4. As heretofore stated, in count 4, the defendant is charged with the crime of public intoxication. Were you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant was under the influence of an intoxicating substance, and 2, that the defendant was under the influence to the degree that the defendant may have been endangered, that there was endangerment to other persons or property, or the defendant unreasonably annoyed people in the vicinity, and that the defendant was in a public place, that the defendant acted either intentionally, knowingly, or recklessly. Public place, intentionally, knowingly, and recklessly have already been defined. If you find the defendant guilty of public intoxication, as charged in the indictment, you shall so state. On the other hand, if you do not find that the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt, then you shall acquit the defendant of this offense. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. During your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. The verdict must represent the considered judgment of each juror. To return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. When you retire to the jury room, you will first select one of your members as a foreman or forelady who will preside over your deliberations. When you have reached a verdict, you will return with it to this courtroom and your foreman or forelady will announce it. The crime charged in each count in the indictment is a separate and distinct offense. You must decide each charge separately on the evidence and the law applicable to it. The defendant may be found guilty or not guilty on any or all of the offenses charged. Your finding as to each crime charge must be stated in your verdict. In reaching your verdict, you shall consider the offense charged in the indictment. If you unanimously find the defendant guilty of the offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense as to the defendant. On the other hand, if you find the state has not proven beyond a reasonable doubt the defendant's guilt, or if you have a reasonable doubt as to his guilt, then you must find him not guilty. In that event, your foreperson will report that you find the defendant not guilty. If after your deliberations you find the defendant guilty, the court will set the punishment at a separate sentencing hearing. The jury will not be involved in setting the punishment. Now, ladies and gentlemen, I have prepared a verdict form which deals with each count and provides, for example, in count 1 in the indictment for the charge of assault, we, the jury, found the defendant, Sherrick Vaughn, either not guilty or guilty, and you check one, and the foreman or forelady signs it, and that's for each of the 4 counts. It'll help you in your deliberations. Now, before you retire to begin your deliberations, I must select the alternate who will be excused from further participation. You are excused with our thanks. You can wait around and see what your fellow jurors decided in the case, or you may be on your way. The rest of you, if you will let him excuse himself from the And you can go out through this door and down through the hallway. Do you have anything in the jury room? Yeah, that'll be through the clerk's office. That they can take you out through a different way. Ladies and gentlemen, you are free to now go across to the jury room and begin your deliberations, and let us know if you're able to reach a verdict. Court stands in recess pending the return of the honorable jury. All right, we are ready to bring the defendant out, please. All right, I'm told that the jury has reached a verdict, but before we bring them back, I was handed, after the jury had been charged and had retired to deliberate, I was handed a motion to dismiss that Mr. Vaughn has filed. And for the record, I will state what the motion says. I, Sherrick Vaughn, come before the courts as affirming the foregoing to be true, and to the best of my knowledge, paragraph 1, I move to dismiss this case for the witnesses, both the officer and Bethany Page, watching the entire processings and verified it, the fairness in having witnesses prepped while my witnesses are without help to remember is prejudice against the defense. Number 2, the state did not give proper notice of their witnesses in chief until a week before trial. Number 3, a false arrest against the Fourth Amendment as Tennessee statute. The officer did not witness any of this, so no public alarm or threat between Advanced Auto Parts store and the Exxon. 4, none of the witnesses' testimony are fresh and believable. My prayer is for the courts to uphold the Constitution and admit this is illegal and dismiss with prejudice. Mr. Vaughn, do you have anything else that you wish to add to that argument other than what's been stated?
Nothing I can prove, Your Honor.
All right. State wish to make any sort of response to this motion?
Yes, Judge. First of all, the officer, as we've stated, was designated as the state's designee to be seated at the table throughout the proceedings. Ms. Page was not in the courtroom at any time other than her own testimony and the closing argument, which was after the close of proof. We have previously discussed, and you have ruled on the state's proper notice. Both witnesses that testify, names were clearly listed in discovery, Ms. Page being the victim and the officer that testified being the author of the report. I'm not entirely sure what number 3 is. Number 4 is a question of fact for the jury.
I am treating this as a motion for judgment of acquittal since it was filed after the close of the state's proof. Whether I treat it as a motion to dismiss or a motion for judgment of acquittal, since we're at the trial stage, I will deal with each of his issues that he has raised. And number 1, he moves to dismiss for the witnesses, officer and Bethany Page, watching the entire proceedings. And I find, as I have already dealt with the officer being the designated legal representative of law enforcement, that the rule does not apply to that individual. And for that reason, Officer Clark would be allowed to remain in the courtroom. Number 2, there's no evidence whatsoever that Bethany Page watched the trial proceedings. The only evidence was that she may have watched part of this morning's motion hearing, which are 2 completely different proceedings, and therefore the rule was not imposed upon her because she was not a witness. So issue number 1 is denied. 2, the state did not give proper notice of the witnesses in chief until a week before. I have ruled on that prior to trial, ruled on it this morning, therefore this motion number 2 is denied. Number 3, a false arrest against the Fourth Amendment. And we have also dealt with that same issue this morning in his motion to quash or dismiss, and I stand on the ruling that I made at that point. Number 4, none of the witnesses' testimony was fresh or believable is a jury issue. Being fresh testimony is not a standard that I'm aware of ever has been applied to anything in a courtroom. So as a result of that, I find that there are none of these bases that have been raised by the defendant in this motion to dismiss are valid, and therefore I deny the motion. You ready to bring it?
Your Honor, I gave you a note earlier today. Would you make a rule on that right quick?
A rule, you gave me a note, said,
Yeah.
please don't dismiss Jennifer to preserve statement for a violation in another case. I don't know what that means.
I didn't have time because I was trying to focus on this, but it was a motion. I need to file a motion to preserve testimony for a violation she witnessed herself in the last case we had here, Your Honor.
Well, I have no authority to hold her, for any reason. So, you can file something and have a hearing set and subpoena her, but as far as me holding someone, she's not under arrest and she's under a subpoena, but that concludes at the end of this trial. So for that reason, your request to hold her to preserve a statement is not something that I
Was she dismissed already, Your Honor?
don't know whether she's gone or not. So. But your request for this court to order that she be held there's no legal basis for doing so. All right, bring the jury out, please. Ladies and gentlemen, I'm told that you have been able to reach a verdict. Is that correct? All right, are you the foreman? All right, let me go over this form with you, and we'll go over this together. As to count 1 of the indictment in the charge of assault, how does the jury find the defendant? Guilty or not guilty? Not guilty. As to the charge, count 2 of the indictment, the charge of false imprisonment, how does the jury find the defendant? Not guilty or guilty? As to count 3 of the indictment on the charge of false imprisonment, I'm sorry, that was a false imprisonment. As to count 3, the charge of disorderly conduct, how does the jury find guilty or not guilty? And as to not guilty. And as to count 4, charge of public intoxication, how does you find guilty or not guilty? So all 4 counts, the jury is unanimous in its finding not guilty. All right, then thank you for your time, and you are free to go until 6 o'clock Monday night when you need to check that number to determine whether or not we need you for the trials on Tuesday. Thank you. I wish I could tell you don't have to come back. So. All right, Mr. Vaughn, the jury has found you not guilty of these 4 counts. That leaves us with 2 other charges. I think that 2 other indictments that still need to be dealt with. So he has a driving on revoked license, 3rd offense that he withdrew his guilty plea on, and we need to set that for a trial. Do you have an idea of when you want to try that, General?
Let me go ahead and get my other files up. I'm going to go ahead and on 2021 CR 462, that is the case with the aggravated assaults, reckless endangerment, and felon in possession of a weapon. State is going to enter a nollie on that after discussion with the victims.
Right.
That will leave us 1 case to set. I would like.
And that is the driving on a revoked license, correct?
Yes.
Right.
I would like, I've not had a chance to talk to one of the THP representatives about his driving history. Could we set well, you have to give us a date. Or could we set it in front of Judge Wallace for him to?
Oh, I'm sure Mr. Vaughn would probably prefer to have a different judge anyway.
No, I like fighting with you.
No. I'm not saying for Judge Wallace to take the trial because you already heard the first half of it. but could you give me a little bit to make a decision on whether the state's going to go forward or let that one go as well?
Your Honor, would that be new witness evidence she's providing? She talking about she need to get a hold of THP?
Nope, you have a copy of it. It's just a person I need to talk to clarify something.
All right. So what are you asking to do about that? We've nollied the one case that you have a victim problem with, and now we're down to the driving on a revoked license third offense. What are you wanting to do about scheduling? You wanting to put it on a date for Judge Wallace to consider setting a date?
I tell you what, Judge, could we, I know you're back for the Godwin case. Would you want to pick a date that morning before trial, or?
As far as I'm concerned, you're talking about on Tuesday, the 28th?
No, I'm talking about November the 6th. I have Cordarius Godwin.
Oh, I forgot.
Yes, you scheduled that.
Cordarius Godwin is set on the 6th of November. I don't have a problem with it. 8:30 in the morning, we'll consider whether we'll have Mr. Vaughn here, and we'll eat.
What you say, November 26th?
November the 6th.
November 6th at 8:30 a.m., we'll have a hearing, a status hearing to determine on the driving on revoked license what you're planning to do, and we'll set a trial date at that point.
You know what, Your Honor? Do I need to put in a motion to, never mind, Your Honor, never mind.
All right, then we stand adjourned.
All right, y'all. So we've come to the conclusion of the trial with the verdict. All right. So out of 8 charges, he was only found guilty on 1. Well, actually, he wasn't found guilty on. He's actually going to be going to another. He's going to be going to trial for the revoked license third offense. But the some of the serious charges like assault and the things that he got tonight. Well, there was 4 charges that, and those charges were assault, false imprisonment, disorderly conduct, public intoxication. So he got acquittal on all 4 of those charges, and then there was 3 more charges that he got a nollie on. Now, a nollie is basically the state saying, we throw in the towel on these charges. We're not going to pursue uh, uh, a conviction on them. They can bring them back up at a later time if based on some technical stuff, but basically, it's an acquittal from the state, and they're not pursuing the charges, so they're just as good as a dismissal. All right, so did a sovereign citizen, him representing himself, work? I don't know. I mean, I think he just, he did a good job with some of the questioning and everything like that. Judge Wolfe handled the case how he handled it, with a really laid back style. But at the end of the day, a lot of technical things went on, and I mean, there was even talks of a mistrial early on. That never happened, obviously. But, I think it's a win for him that he has one more fight that he has to fight, which is, the revoked license, third offense. He's going to go to trial for that. And he's probably going to be representing himself with that. All right. So anyway, I just want to thank you for watching. Like, comment, subscribe to the channel. Also hit the notification bell so you get notified when I upload more videos like this. This is Carl from Sovereign Citizen Chronicles. And also let me remind you that part 1 and part 2 of this trial will be down in the description below the video. All right. This is Carl from Sovereign Citizen Chronicles. I'll catch you on the next proceeding. God bless. Peace.